speaking. Otherwise, there's a big echo.
Good morning. Can we hear each other? Hello.
Morning to me. I can hear you.
You can hear me? Yeah, there's a big echo.
Yeah.
And I see there's 66 people already logged in.
To me, do you have more than one device on?
No, I am only logged on only one.
Is it the echo? The echo on my side is gone now. It's better now. I'm not sure on your side.
The people that is not speaking must mute their mics. There's a lot of mics on the thing.
That's better now.
Yes.
So I think, Selma, your mic might be the one with the problem. After she muted and then it went quiet. Oh, you know why? Is it two people in one office? Selma and Vainant. So they must just maybe be separate from each other or use one thing. That's what maybe the reason why the noise.
That's much better now.
Yes. Okay. Thanks, is to me.
Okay, are we ready to start?
Yes, ma'am.
Are we ready?
Some will join, some are maybe on the phones, we can't see them.
Okay. Okay, good morning, colleagues, and thank you all for the wonderful response. I see now here we have 73 people who have joined. Yeah, the RSVP was over 80 people. So yes, we are expecting more people to join us. Just a few house rules that all mics must be on mute unless you are the one speaking. All cameras must be on mute, must be off. Hey, yes, all cameras must be off, and that is going to keep the quality of our sound better. Yes, there is an we will have, there are all those indications, there are signs for you to raise up your hand when you need to speak. But what we are going to do, we are going to follow the program. Petra, can you show the agenda, please? Petra?
I'm there. I will share it
Okay.
for us.
If you share the agenda, we will follow the agenda as it were. We will have two presenters. The first will be ND, Mr. Adimulam. He will go through all his slides because they are all his presentations. He's presenting on those amendments, and because they are related, all of them. We would want him to go through all of them, and then questions can be sent. Thank you. We have the agenda here. I hope, can we all see it? Can we all see it? You can just show by your sharp sign that you are able to see the document on the screen. Perfect. I can see the response. Just a second on my side. My battery, I'm trying to write. The program is then as presented. We will have Mr. Adimulam presenting number two, number one. I am doing the first item, which is opening and welcoming, and then Andy will cover all those government gazettes amendments on the rules. The rule number 9, that one will be the changes on the domicilium. There is a little bit there of dancing stuff on the screen. I don't know if it is only on my side, but yeah, good, better again. So he will present on that, on number 2.1, number 2.1, 2.2. This is still service and domicilium. High Court, Magistrate, Movables, High Court. So up from number 1, allow him to present whilst throwing them questions on the chat. Once he is done with that, then we can deal with all the questions, and then we will then allow him to go to 2.5 and 6. We will take questions thereafter, and we will do number 3, conditions of sale, which will be handled by myself, 3.1 and 2, and then we will take questions. I hope that is clear. And thank you. As you are all aware, this is the second the second training of this nature. Once again, we thank you for your response. Those I have touched on the rules, and on expected training. outcomes. From my side, really the outcomes that we are hoping for is a better understanding of these rules and ease of application by members. And the engagement should not stop here. Once we have had this training and our discussions and we have that better understanding, if there are any challenges, uncertainties, once more arising either from the rules themselves or even from the discussion, we have our very vibrant WhatsApp group that we use to discuss what we will not have covered here. If there are any other expectations, please can we throw them on the chat? We will reflect and share them as we proceed. Right, thank you. And at this point, I am going to hand over to Andy to start right away with number 2. We have 2 hours exactly from 9 to 11, and hopefully we would have covered everything that we intend to in that space of time. Over to you, Andy.
Good morning, all. Welcome to our second training session, as Tumi mentioned. You can all hear me this time? Just show me a thumbs up, you can hear me. Okay, so I'm loud and clear. So, like I said, welcome. Good morning to the President, National Exco, my training committee members. Thank you very much for putting this together. We trust and we know that you're going to have a successful training session and much knowledge you are going to gain. So the first thing that you need to have with you is your government gazette, which was sent to you. I see Petra's put it up on the screen again. So it's a very big gazette, so we'll only go to certain pages. But I'm sure some of you have already implementing these rule changes, but we just want to highlight certain other than you just affixing it, other relevant points that you need to insert on a return. And this is where the deputies and the data captures are very, very important, because obviously whatever the deputy states on his return, and if it's not on the, or whatever he states on his slip or his whatever he hands back to you to type, if you didn't insert it, it usually will come back and then they will say no. The deputy will say one thing, and then obviously the return has to be amended. So on page 14, you will see that Rule 9, there was a big celebration when it went back to the old ways. The attorneys didn't know what to do. Sheriffs didn't know what to do. But eventually the rule was able to sort this out. So a very big thank you again to Prince Malaleko, who sits on the rules board. He prompted and he pushed, and obviously the rules were amended. You'll see Rule 9D. It said if the person so be served at the domicilium by delivering a copy, therefore a person apparently not less than 16 years of age at the domicilium chosen, provided where possible, service at the domicilium so chosen shall be affected by delivering a copy of the process to a responsible person, apparently not less than 16 years of age, provided that if no person is present at the domicilium, then the sheriff may leave a copy at the offset domicilium, the sheriff, and set out in the return of service, set out the details of the manner and circumstances on which the service was affected. Now, many a times you will see that the attorney will tell you, just go to my instructions are for you to affix. You must affix it. But if you look at the rule, it says by delivering a copy. Nowhere there it says affix by leaving. You have to leave a copy. There's nowhere in the rule it says affix. So when you type, or I'm sure that those that supply the computer programs will note that obviously they have a set template that word remove. They must remove that word affix they must state leave or hand or vice versa. So you must make sure that your return must read that. And the second part of it is if you leave the copy, you can't say lock. You have to, obviously, what was your search and inquiry? Because there's a subsection, it's not in the rules now, but there's a subsection that's there that says, what search and inquiry did the sheriff undertake? Because the last resort you would do is just to leave the copy there. You will just not go the first time and obviously leave the copy. You must say what search and inquiry did you do. I went to the neighbor says no, the person left. Then you can leave the copy and inform by Andy, neighbor, that the defendant left. Then it is up, the onus will lie on the court to see whether they'll grant the judgment or not. So that, guys, is straightforward. The next one that came into operation is Rule 4. That's in the High Court. And you'll see on page 19, it says the same from 2, Rule 4 is hereby amended by substitution for paragraph I4, paragraph A of sub-rule 1 of the following paragraph. If the person so be served at the domicilium by delivering a copy, therefore a person apparently not less than 16 years of age at the domicilium so chosen, provided that if no person is present at the domicilium, the sheriff may leave a copy at the offset domicilium. So yet again, the same principle will apply. There is no word affixing there. So when attorneys tell you to affix, they actually mean by leaving a copy, because they still will use that term affixed, but the sheriff cannot say affixed. So your typing has to change, and obviously the rule has changed now, so the rule subsection has changed. And you all know that it has come into play from the 27th of December, and it should be up and running in your offices. You will see, especially in immovable, they will ask you a very rigorous return. You will have to say you went in the morning, you went in the afternoon, and you went on a Saturday. Then after that, you may leave a copy, or then you may serve it. That's the term they will use to you. So those are the search and inquiry. That's what needs to be on the base of the return of what you did. Allowing you to do the last resort was to leave the copy on the premises or serve it on somebody because the person has left. They will usually want that from you. And some of the attorneys will insist, no, you haven't done a search and inquiry. You just made one attempt. Now we can't get judgment. And the cost is going to be on us. So you rather read the instruction letters, see what they're asking for. You, the sheriff, you compile the return. Based on your return, judgment is given, and you know what happens. Then the attachment will follow. Then obviously attaching of the immovable property, so or sequestration, and then the person say, well, but I never get the summons, so it's going to come back to the sheriff ultimately. So you start the initiating legal process by you serving the summons correctly. So I hope that that whoever's on the platform take it back to your deputies. I hope the deputy forum is represented, so they will know that this is what they need to say to the members, that you're not a postman. You're not a postman, you're not a courier guy. You're an officer of the court, and there's set rules that you need to abide by. And what you write is what the data capturer will write, and that's the return that will be produced in court. You can't backtrack after you've signed that return. Therefore, deputies, when you are signing your return, make sure that you read your return. You are the one that served it, not the sheriff, not the data capturer. You serve the document, you know exactly how it was served. And if you are happy in what you have served and the rule is right, then you place your $1 million signature on it. If not, you have to correct it straight away before it leaves your office. All right, so we've done with 2.1, 2.2. If there's no questions on the chat box, I'm sure Tumi will alert me to that. Then we can get going. Okay.
As I see there's a question. Okay, Andy, there's a question there. Is it a question or I can't see the whole thing, but it has to do with a post box. I don't know if the question, if you can see that.
Good morning. If left in document imposed
Full question there, does it say post box?
No.
Is it a valid? Yeah.
It won't be a valid service because you say you left it in the post box.
And
The rules doesn't
do you have the
provide you
question?
to. Yes, I saw the question on the chat box. The rule is clear. No way it says that you may leave it in
The post box.
in the post box.
Okay.
So if you are attaching a rule to what service you made, it will be an invalid service, and those are the ones that can come back and bite you and say, no, but I never got the document. Even if the defendant did get the document, say, I never got it. And if he goes to an attorney that's quite clued up in litigation, he will say, no, the sheriff is at fault because there's no rule for. So just cautionize your deputies when you come to those type of services where you cannot get any service and you know it's impossible to serve the summons like the way it's requested in the rules. I suggest that you get hold of the instructing attorney and say to them, this is the predicament, this is what I'm battling with, I need your instructions. Possibility they might come back to you and say, you know what, return the document, we will serve it at his home address, at his employment address or another address that we have. So try to be, in what you are doing, that you do it to the best of your ability and in a professional way. Then we're going to deal with, guys, 2.3 on the agenda, pages 19.
And Andy, there's more.
Okay.
Hi, Andy.
Yes.
There's more follow-ups on that question.
Okay.
So the question there was, if we do not use the word affix, do we say document was left at the door or gate?
Yes.
Yeah. That was the question on the affixing.
Yeah. I think most of the sheriffs usually apply that principle. Document left at the door or left at the gate, but not post box, guys, is not something you should touch on because it's not there in the rules. Those words is covered when you say left at the door or gate. But when you say affix, even our magistrates that we have a good relationship in the Boys Court because there's only 2 sheriffs, and when we go for those meetings and when they see that word affix, they really flip. They say there's no affixing. So we say no, it's the citation, or it was typed incorrectly. So they openly say no, you must check your return, make sure it's done. So yes, that word affix, they tend to know it's not in the rules now. So try as much as possible to change your return and maybe just change it in a way that you know what you mean. The first attempt to serve on the first attempt service. That one, Mr. President, is a tricky one. Some of the attorneys will say, it was a domicilian. I asked you to serve on the first attempt. I never asked you to make an attempt. There you'll have to be guided. You'll have to be guided. Okay, I affixed on the first, but what search and inquiry did you make, Deputy? Did you find out from the neighbors? Did you go in the morning or while you're en route, did you have this one, or did you phone? There was a number to phone. Did you phone? Those are the things they want to see on the return. By you just going and serving it the first time without no search and inquiry, and they're going to say, no, the rule says you must just serve it. It's a domicilian. Why didn't you serve it the first time? But you need to say to them, please look at the rule properly. After, especially Rule 9. Rule 9 says, and set out in the return of service the details of the manner and circumstances on which such service was affected. What circumstances? What did you see there? Or what did you gauge? Or what information did you get? And then after that, you served it. So I think that is what they're looking for. Going and serving the first time, I usually don't like it. I know attorneys will, most of the time in my office will say, but I'm not going to pay you. I say, okay, what the hell? As long as I satisfied myself that the deputy went in the morning, it was locked. Then he went there 2 days after that, he still found it locked and he served it. But we just have to obviously guard your deputies and obviously guard your office. Attorneys will just misuse the rule and just tell you what to do, but not realizing that when they do go to court, they are then questioned. No, there's no search and inquiry. It was just served. On what circumstances? Remember, the court has to apply the rule. Hear the other side. How did Andy actually get the document? Did he get any knowledge of the document being served at the domicilian? What did the deputy actually do? So those are the things I think. I hope it answers your question, Maxi. So where may we leave the document if not in the post box?
Yes. Yeah.
Okay, if there's an entrance, the gate, yeah, you can place it on the gate. Post box, I think maybe Anna may be referring to those buildings that are that have security and only have post boxes in the front. That's a bit of a tricky one. That I think each office does it differently. And if you feel that serviced by post box and the courts are accepting it until one magistrate or judge picks it up, might just come back to bite you. I know the rule where for chosen domicile it was served on the security guard. And obviously it went to court and the defendant lost and the judge said, no, it was fine to serve it on the security guard because there's no other way that the deputy or the sheriff could have gained entry. And the guard was the only access point and he didn't let the sheriff in, so he served it on him. So there again, you have to contact the judgment creditor's attorneys. You know the situation that people find themselves. Everything now is about debt. Everything is about that 60 billion rand case that's going to court. People losing their houses because the banks and all that. But it's coming back to what was the initiating process. What was the first process that was served? If that was served incorrect, the entire judgment is incorrect. So I'm just putting it out there that you guard yourself. I know it's hard to answer the question, guys, about post box. Yes, it'll apply when you do security buildings that nobody wants to let you in. But unfortunately, it is what it is. We have to make sure that you put everything on your return if you put it in the post box. If that was your last resort, then you'll have to state why you put it in the box. Did the attorney ask you to go 2 or 3 times and then you put it in the post box? So those questions will lie with the attorneys and the answers obviously will come from the sheriff. Okay, so we are done with that one. Is there any more on this subject? Can we move on? Okay, I see there's nothing. So we'll now go to page.
Not that I can see.
Right.
Yeah, Annelies was the last question. I'm sure we can go to the next.
Okay, so guys, page 19 on your government gazette, you said there's right on the top there, amendment of rule 45 of the rules. These rules were very interesting because it answers a lot of questions, and when sheriffs are looking at or staff is looking at an amendment, always look to see what sub rules were changed and what was added. So then you know which ones were changed. So you'll see a 3, they got 3A underneath by substitution for rules 2, 3, and 4. So in other words, there was never 42, 2, 3, or 4. Now they've added it on and they're saying there's sub rules to it. So that is where you know now, oh, these were the changes. This is where the changes are. And this one, I think, it was a big contention because most of the times attorneys will tell you, there's the writ, and then on the day of the sale, they send you a letter and say, no, these are my tax bill of costs. But here it answers it very well. So make sure that in future, this is what your office needs to adopt. It says no process of execution shall be issued for the levying and raising of any cost awarded by the court to a party until it has been taxed by the taxing master or agreed to in writing by the party concerned in a fixed sum, provided that it shall be competent to include a writ of it to claim for specific costs already awarded to the judgment creditor but not then taxed, subject to due taxation thereafter, provided that if costs shall not have been taxed and the original bill of costs duly allocated not lodged with the sheriff before the day of the sale, such costs shall be excluded from his or her account of plan of distribution. So straightforward. If you don't have a tax bill of costs, it cannot be included in your plan of distribution. So the same will apply, obviously, in your immovable. Usually they'll give you a tax bill of costs. Some don't, but obviously this will apply in your movable. So make sure you have a tax bill of costs. And I think the same thing would apply in the match court as well. So if you're doing it in one, you can always do it on the other. Then 3, this is the new one. It says whenever by a process where the court is commanded to levy and raise any amount, sum of money upon the goods of any person, the sheriff shall forward himself or by such sheriff's assistant proceed to the dwelling or place of employment or business of such person unless the judgment creditor gives different instructions regarding the situation of assets be attached. And there, first you need to demand, so that needs to be on your return. You demand it, and failing satisfaction, you ask for a pointing out of the movable assets, and then obviously the assets were pointed out, and then you did the search and inquiry, and then you found the property, and then it says that you can do an inventory, and subject to provisions of sub-rule 5 shall be taken into custody of the sheriff, provided if there is no claim made by any person to such property seized or about to be seized by the sheriff, then if the plaintiff gives a sheriff an indemnity to his satisfaction to save him or harmless from any loss or damage by the reason of the seizure, therefore the sheriff may retain or shall seize, as the case may be, make an inventory and keep the said property. Most of the time they say no, all ICOT is attach and remove. But you'll see some attorneys saying to you, no, I just want you to make an attachment only. So those are the instructions you need to read. That is where sub-rule 3, it says they'll give you different instructions. Some will say, attach and remove, your indemnity is there, it's the High Court, I want you to attach and remove. Some will say, no, just make the attachment and I'll give you further instructions after that. I know there was a question where stuff was attached and there's an interpleader or an affidavit that was given. Do I sell or do I remove? Some sheriffs opt to say, okay, we'll remove based on the instruction from the attorney. Then they'll say, okay, then issue the interpleader. That each party, each sheriff does it differently. Obviously, it says that if you receive a claim made by any person to such person seized or about to be seized by the sheriff, then if the plaintiff gives the sheriff an indemnity to satisfy him harmless from any loss or damage by reason of the seizure, the sheriff shall retain or shall seize, as the case may be. So that discretion will be left, obviously, on the instructing attorney. Yes, the sheriff went to remove, but there's an affidavit in place. Okay, sheriff, you know what? Leave the stuff, attach it, but obviously issue the Rule 58 interpleader. So that is where you'll be guided. Then the next page, you'll see on page 20, it said that if the satisfaction of the writ was not demanded from the judgment debtor personally, the sheriff give to the judgment debtor written notice of the attachment and a copy made by him, such sheriff, unless the judgment debtor's whereabouts are unknown. You'll have a scenario where you'll attach in one place and the defendant, or a place of storage, and then the defendant is residing somewhere else or is employed somewhere else. So it is imperative that the sheriff completes the attachment by serving. You'll get some attorney says, no, the asset is at the place of storage, attach it there, serve it at the place, that's right, and then give me a sale date and sell. No, you have to serve the defendant immovable as well, wherever it has to be found, in order for your attachment to be completed. I know the next question is, in case the defendant cannot be found, until the defendant is found, then only can you proceed with that. It is up to the judgment creditors' attorneys how they're going to move forward, whether to publish it in the paper or get some address of his family or last known person and then complete the attachment, then so be it. The new one that came in, you'll see the sheriff shall file with the register any process with the return of what he has done, and furnish a copy of such return and inventory to the party who has caused the process to be issued. This is the new one because we never would have served the register. Usually it's now for immovable. But now they want you for movable to serve on the register. So that is going to be another challenge for sheriffs. I guess the same route they'll follow is to serve like the way they do the immovable on the registers of their jurisdictions. Then 4B, it says by substitution of 7 for paragraph 7A. This is where now they're saying no, there's a paragraph, but we're now inserting 7 and we're now going to make it a subsection. So where any property is attached, as offset, the sheriff shall wear practical and subject to Rule 58, sell it by public auction to the highest bidder after due advertisement by the execution creditor in a newspaper circulating in the district in which the property has been attached, and after the expiry of not less than 15 days from the time of seizure, provided that. So you see that now they're setting out the time for the advert to be placed. Before it was never there. Some sheriffs used to apply the movable 5 days and carried on. Now they're telling you no, it has to be 15 days. So it gives you clarity, and the execution creditors' attorneys needs to do that. Provided that the auction may be conducted via electronic platform simultaneously with the physical auction, and the auction shall be conducted in terms of the CPA, Rule Section 45 CPA, and regulation promulgated thereunder. Just for, okay, I see there's a question, just for clarity, do you mean a writ has to be surplus before attachment can be done? If you get personal service, then that's good, but it says right on the top of the Government Gazette, it says the sheriff shall give the judgment debtor written notice of the attachment and a copy made by him unless the judgment creditor whereabouts are unknown. So there, I think, generally, if it's served on anyone over the age of 16 years, he would obviously come to know about it. If it's served personally, it's good. But how we are doing it, I think that will suffice for now, Yvonne. So I think they're talking about where is unknown at that address where you made the attachment. But if you find him somewhere else, you have to serve him personally. It's like what I just mentioned earlier on. Your attachment will not be complete unless the defendant is served. So maybe they mean personally, meaning if I may be residing in Johannesburg, but I stay in Durban, but you served the process in Durban, but you didn't serve it on me personally, but you served it on somebody over the age of 16 years that I'm attached to or related to at my house or at the workplace where I am, that should suffice because the defendant did get notice of the attachment. So I hope that answers your question. Okay, so 7A, I'll talk more about that when we get to the CPA in terms of online auctions because and selling in the CPA. Just recently, we were awarded an order by when we were doing for REF, and we had to conduct the sale in terms of the CPA and how it needed to be done. And the judge illustrated. Obviously, there's no cost against us, but it said us exactly how it needed to be done. And even if we enforce a reserve price, we can do it. So it's something I will share with you later on. So C, it says by the subsection of sub-rule 8 for paragraph C1, the following paragraph, in case of the attachment of all incorporeal or incorporeal rights as of said, the attachment shall only be complete when the notice of attachment has been given in writing by the sheriff to all interested parties.
Excuse me, Angie.
Yeah.
Can we please all mute? Can we please all mute the intervening voices in the background? Thank you. Thank you.
Okay, I see. Yeah, most are muted. So he says this attachment in terms of incorporeal rights is only completed, your notice, when the notice of attachment given by the sheriff for all interested parties, the assets consist of incorporeal movable property or incorporeal right in immovable property. Notice shall be given to the register of the deeds, whose deeds registry the property of the rights is registered, and the sheriff have taken possession of the writing or document evidencing the ownership of such right, and shall certify that he is unable to, despite diligent search, to obtain possession of the writing or document. So if you cannot get hold of that certificate, you have to give it, you have to certify that you are in writing that you're unable to obtain such document. It will only be complete after you've got that in your possession. Same will apply when obviously we attach shares and rights into assets or shares in a company. D is by the substitution of sub-rule 10, where the property subject to a real right of a third person is sold, such sale shall be subject to the rights of the third person unless such third person otherwise agrees. So in other words, they're talking to you about, I think, section 30, I don't know, is it section 30 in the business, where if you sell the shares, it has to be obviously offered to the other members, and if they come back and say, no, we're not interested, then only the sale can obviously proceed. Yeah. So make sure that you know that. Otherwise, you cannot just say, no, I didn't offer it to other people, and then you might get an application saying, no, it was not offered to me first, and why did you proceed with it? Then E, page 21, he said the sheriff conducting the sale not less than 10 days prior to the date to forward a copy of the notice of sale to all other sheriffs appointed in the district where it has been instructed to conduct the sale in respect to attached provided that where the auction is conducted via electronic simultaneously with the physical auction, other notices of sale shall comply with the provisions of Section 45 in terms of the CPA and regulation promulgated thereof. I think this was Rule 3(2)(b), where there's more than one sheriff in a jurisdiction. So that applies there. If there should remain any surplus, the sheriff shall pay it over to the judgment debtor, and the sheriff shall make out and deliver the judgment debtor an exact account in writing, the sheriff's costs and charges of the execution and sale, which shall be liable to taxation upon application by the judgment debtor, and if upon taxation any sum shall be disallowed, the sheriff shall refund such sum to the judgment debtor. So if you got any surplus now, this is something new, you will have to make sure you give him obviously your plan of distribution, and if there's any charges that are there, the debtor will then say, no, I want to obviously tax your bill of costs. Obviously, you'll have to abide, then you'll have to obviously abide by the taxation, and then you would obviously refund him if you took your money before. If not, then it will remain. Then F says, by the substitution in sub-rule 12 for paragraphs A, B, C, and F. So in other words, it was 45(12), remember? Now they have now included subsections or sub-rules to those paragraphs. So you got 12A, wherever is brought to the knowledge of the sheriff that their debts are subject to attachment and owing or accruing to a third person subject debtor, the sheriff may, if requested by the judgment creditor, attach same, they serve a notice in such way they are therefore after called the garnishee, requiring payment such garnishee to the sheriff such much debt as may satisfy the writ, and the sheriff may upon such payment give a receipt to the garnishee who shall be discharged pro toto of the debt attached. Then B, in the event of the refusing to pay or comply with the notice, the judgment creditor and the judgment may call upon the garnishee to appear to show cause why the garnishee should not pay the debt pay the sheriff the debt due or as much as sufficient to satisfy the writ, and if the garnishee does not dispute the debt due or claim by him or her to the party against the execution issued, he or she does not appear answer to such notice, then the court may order the execution to issue and may issue accordingly without any previous writ or process for the amount due for the garnishee or such much therefore as be sufficient to satisfy the writ. So you see now they gave you a different change. They say now if they're aware that if a third party known as a garnishee is holding money on somebody's behalf, they will instruct the sheriff to go and attach those funds. And if the garnishee has a problem with it, then he'll have to go to court and show cause why he doesn't want to pay. And if he does pay, then obviously that is settled. They say if the garnishee then disputes the liability, the court may order the execution respect as may be admitted. If none be admitted, then the court may order that any issue or question necessary would determine the garnishee's liability to try to determine any manner mutandis in which any issue or question action may be tried to determine, or the court may have such other odd imprimis or just. F, it says where the sheriff is of opinion that the applications to court or orders with respect to the garnishee will probably cost more than the amount to be recovered, the sheriff may sell such debts after attachment by auction in the same way as any other movable property, or cede the same in normal account, therefore, to the judgment creditor, such creditor's consent. So this is new. So some will say, okay, you as a sheriff, you come to an opinion that this is not going to recover. Then they will say, okay, you are the sheriff, what are you going to do? So most of the sheriff will say, okay, we'll attach the right title and interest into that, whatever the garnishee is holding, and whoever buys it obviously will have to comply. So F is where the sheriff is of the opinion that the application to court with respect to the garnishee will probably cost more than the amount to be recovered. The sheriff may sell such debts after attachment by auction in the same way as other movable property. So this is something new, and this is something where you will be faced with and challenged with. If the rules for the CCMA was still being used in the High Court, believe me, you would have had a mountainous job, because that's when you can go directly and attach the bank accounts of the employers using this portion or this sub-rules there. Then he says, G, but the substitution for sub-rule 13 of the following sub-rule, neither a sheriff nor person on behalf of the sheriff had any sale, purchase any property offered for sale, either himself, such sheriff, or any other person. That includes your staff as well. You, the staff, the sheriff, no one can buy in your sale. And there was a lot of hype about it. It's more to do with the ethical background of it. Martin will obviously explain when because Andy is the sheriff and these staff work for Andy. They want to buy the stuff, and then the purchasers say, okay, yes, we work with these staff, so we will buy it and then we will sell it to them. Then the debtor gets hold of it and says, yeah, the reason why you'll never bid it so high is because you know the sheriff and you know the staff, and therefore you bought my stuff at this price, and which can be challenged if they find out, and you don't want to go through that, and neither do you want to put your staff through that process. So it's better they stay out of it. So it's in the rules, guys. It's there. I didn't say it. It's what the legislature say. All right, so there's no questions on this one for movables?
Yeah, I saw there was a hand by Max. I don't know if it was a response to some of the questions or just a question. Max, can you come through, please?
No, it's okay. It was that issue of muting. Thank you.
Oh, all right. Thank you. You can proceed, Andy.
Okay, I see they say online auctions. Yes, I think we will deal with that when we come with the CPA online auctions. Then amendment to Rule 46 is just 46A, then the sub Rule 5. It says subject to Rule 46A, any order made by court, no immovable property which is subject to any claim preference of the execution shall be sold in execution unless there's the new insertion by subsection Rule 7 for paragraphs A to B. The sheriff conducting shall appoint a day of the sale, such being example or special leave of a magistrate not less than 45 days after the notice of attachment, provided inform all other sheriff appointed in the district at the day and sale day and place, provided the auction conducted by electronic simultaneous with the physical auction. The auction shall be conducted in terms of the CPA. The execution shall be of consultation with the sheriff conducting the sale, prepare a notice of sale, a short description of the attached immovable property, its improvement, magisterial district, physical address, time and place for the holding of the sale, and the fact that the conditions may be inspected. The sheriff's office conducting the sale, the execution shall furnish the sheriff with many copies of the notice of sale that may require. By substitute 8 for paragraph 4 or paragraph A of the following, the sale in execution and conditions shall comply with the provisions of any law relating to auctions, in particular section 45 of the CPA and regulations. Then they say the form uniform is hereby substituted by the following form. So you see they would have attached on the same a copy of the conditions of sale. They would have attached a copy of the conditions on sale. So I think that was the one that they say regional court, but it is something that obviously the SASS and EXCO has been talking about, is to hold a meeting with the banking forum in order for them to adjust the conditions of sales. And I think that is where also the Tumi will touch on the case law. And that is what the buyers or the creditor that buys from us mostly said that is where the problem was lying. They had a problem with the conditions of sale. So 2.4 and 2.5 together with 2.6, we will deal with, I think it's page, if you got your the CPA, I think it's on page 48 of that attachment. I just want you to go to page 48 of that attachment and you'll see it's section 31, internet or electronic auctions. I think Petro will put it up. It's in the Act, page 48 of the Government Gazette of the CPA. 48. Petro, page 48. Yeah, just scroll back up. Okay. All right, there's it, guys. So this will obviously coincide with 2.3, 2.4, 2.5, 2.6. You will see that if you're going to conduct auctions online, the rules now allow for it, and the conditions have been made to come in line with it in terms of the CPA. And you can advertise online as well. That rule change happened long before this one. I did see it there. So it says an auction may be conducted via the internet or electronic medium or platform, irrespective where the server or other electronic medium or platform is situated, only if it meets all requirements in respect of an auction provided for in its regulations or applicable law, but with the necessary changes, if any, to suit an electronic medium or platform. So nearly all the sheriffs are complying with the CPA. You should be complying with the CPA. So that is why they're saying that you can conduct this auction as long as you are using all relevant law that goes with it. So obviously CPA, you're using fee-kind your buyers, and you're doing all the necessary and collecting the registration bids. You must note it says in the CPA, if a person is not registered, you cannot take the bid. And the rule says simultaneously. So in other words, an attorney can come to you and say to you, I want my movable property sale to be done online and on site. And once an attorney gives you that, then obviously it becomes a tedious task, because now you will have to have somebody controlling your online auction, and obviously somebody controlling your on-site auction. So, and if you're going to get a bid on site, you'll have to relate that bid to the person that's online. And that is where a lot of admin will be involved. Unfortunately, it is in the rules, and attorneys are going to use that more so ever now, is because of the syndicates that are found in sheriff's offices, that they buy the movable assets for a song, then they do their own auction outside, or they take it and they resell it to make a profit. So this is where you will have to apply your mind now. There's something that members need to understand. You are a sheriff, you sell in a sale and execution, and you are using the CPA. Do you know that you can set a reserve price in your sales? I've done it. I've sold for it. I've been questioned, and I told them, please, if you want, you can challenge me. And believe me, if they take it to any magistrate or any judge, and you selling assets of defendants, and you trying to get the most possible best price out of that sale, they will side with you. SASS gave us a reserve price once. We never got it, and they reduced it, and we got it, and then the person bought it. And it was a sale in execution. Because remember, when you are selling in terms of the CPA, you're selling as a sheriff, but you're selling as an auctioneer. So those rules that you are setting out in terms of 45 and the CPA are auctioneer rules, which you are the sheriff and you're selling. So that doesn't stop you to say, you know what, I'm setting a reserve on this. And then most of the CCMA cases, you set a reserve and you say to the applicant, you say, this is what, make sure you have the applicant there and say, we're not going to get this, this is what, that is, as a sheriff, you have to gain the most out of those assets you're selling for the benefit of the plaintiff. So it says here, it meets all requirements in respect of an auction provided for these regulation or law with necessary changes, if any, to suit an electronic medium or platform. In the relevant internet website or electronic medium or platform is generally available to anyone over the age of 18 years at the time of the day. So I know someone said, but in case you get a child, they said, no, do you know that kids are very smart in technology, and you're going to get a person that's 12 years that registers on your auction online? How would you know it? It says, well, if you don't comply and pay the purchase price of 10% or the commission, then you know he's underage. You need to be careful of that one. So you need to know that the person that is online is over the age of 18 years. The relevant internet website platform provides high standards of security electronic transactions. In other words, they're saying it needs to be protected from any fraud or cyber fraud that might prevail in the domain of internet. And it says the relevant internet website or electronic medium or platform provides for easy access to all records prescribed in terms of the regulation in a generally used or accepted medium or format. The internet auction provider keeps the information contemplated in Regulation 28.4. For the purpose of the Regulation 26.2, a prospective bidder in an auction to be held via the internet or any electronic medium or platform must register by providing the following: his or full name's identification, passport number, age, physical address, internet protocol address where applicable, login code or name and password, and the details of the means by which payment will be affected. An auctioneer conducting an auction via internet or any other electronic medium or platform may not exclude liability if any goods purchased by the auction are not delivered to the purchaser thereof. So I only touched on online auctions because it pertains to this section in the CPA. Every other section you ought to have been having a CPA Act in your office, because it tells you everything how you need to comply in terms of the Consumer Protection Act, because you are selling immovable properties, you are selling movable properties, and now they want you to go online. And when it's going to go online, your task is going to be even tedious, because they ask you a lot of things in terms of your online auction, how you need to guard the information of the person that's bidding online, and his information, and your information. So those officers that where attorneys are now going to chat, they are saying to you in the rules, I want you to sell it simultaneously. And this is what I want you to do. And if you are not familiar with how these processes are handled, you are going to have a problem, and the pressure is going to be on you, because the attorney is going to insist you have an auction online and on site. I think when we in February, I think around the 26th, I've got a sale, and they've given me a valuation of the goods attached, and they want me to start with the valuation of what they got from a third party as the opening bid. And when I had a look at it, I knew that if I say no, sheriff sale is a forced sale, they're going to say to me that you are selling in terms of the CPA, you're an auctioneer, we set a reserve. So I said, okay, it's fine, we will start with your reserve price, but remember, it's a sheriff auction, it's a forced sale, and your client needs to be there to safeguard his interest, and he will have to negotiate. We don't get the reserve of 2,000 rand, he'll need to tell us, okay, I will accept 1.5 or whatever amount. But if he's going to get no bid with 2,000 rand, then we're going to say to them that there's no bid received on this lot, and it's going to be held down. So these are the things you're going to encounter as a sheriff as it gets, because of the complexity of the debt that is out there and the protection by the courts that they are giving to the distressed society out there. And the sheriffs are part of that process that needs to make sure that the creditor gets the most out of it, further that the defendant is not prejudiced by whatever actions that we take. So now they're saying to you simultaneously.
Okay, Andy, whilst you are there on the reserve price and how do we deal with it, starting with making it an opening bid and so forth, there is a question there. Do we request the attorneys to amend their sale documents from without reserve to subject to bondholders' reserve? Or what happens if the buyers do not bid on the bondholders' reserve? Can the applicants blame the sheriff for not selling the property without reserve? That is, if there was no reserve.
No. Three things to me on that one. First, when it comes with a reserve, you must know when sheriffs are always seem to have this issue of reserve price. You must note that the reserve price that you get via court order is the court reserve price. Then you get the bank agents coming with the bank bid. So the reserve may be set down by court for 450,000, but then the bank will say, no, we're going to bid. We're still going to bid, and how we're going to bid let's say their bid is up to 800, and they're going to say, we're going to bid up to 800. So in that scenario, okay, the court reserve was met and it was sold for 800. Where you do not get the reserve price, it is clear that whatever court reserve was set, it's obvious that there was no reserve price, so nobody bid it, so there's no bid, no sale. I will never take an offer. I will never take an offer when there's a court reserve. I will do the report in terms of the rule because that's what it says I need to do. I never got my reserve, so these are the bidders that were there, and this is the list. I never obtained a bid. This was the last bid, or this was the bid that was made. And why was there no further bids? Because on my application, the rates and taxes was 89,000, but the levies was 900,000, and the court reserve was 450. So therefore, there was no bid, no sale, and according to the buyers, the rates outstanding together with the levies and the market value of the property exceeds the market value of the property that is on sale. That's the report I give to court. So I will now leave it to the judge to say, this is what the sheriff says, and this is the valuation, and this is the cost. What does the sheriff do? Okay,
Okay.
you'll have to resell with no reserve because he knows that the levies and the rates has to be.
Okay, I see there is okay. Maybe on this same question, you see there would be two reserve prices. There would be the court reserve price, and then there is a bondholder a reserve. You know, there would be a mortgage. There would be an amount of what is owed to the bank, and that making the bank the friend creditor. How do you deal with that? I think this is how I want to interpret the last part of this question.
So you got a court reserve, and then you got a bank reserve.
Somebody there is somebody calling Andy.
So I'm trying to explain the question that I asked in the group. So what's happening is that the court order, it granted an order without reserve. This is a corporate matter, and the court granted an order without reserve. So we were supposed to sell the property without a reserve price. However, there is a bondholder that is involved in the matter, and they provided their reserve price in a manner of a certificate of balance. So my question was that, do we then accept that certificate of balance as the bondholder's reserve? And secondly, if the attorney, because the attorneys send their documents stating without reserve as per the court order, do we then change the document to from without reserve to, subject to bondholder reserve? And then lastly, if the bidders don't bid on the bondholder's reserve, can then the applicant, which is the body corporate, blame the sheriff for the property not being sold on auction because their court order says without reserve, and the sheriff insists on selling the property based on the bondholder's reserve? What happens in that case? I don't know if I'm clear, but if you can.
No. Okay. So I understood what you said. You said the court said there was no reserve because obviously you're selling for the body corporate, but there is a bondholder. There is a bond.
Yes.
So the bondholder has told you, this is my bond. Okay. If my bond is settled, then obviously you can sell the property. And the stance is correct. The court may be said without reserve. That doesn't allow the plaintiff to not commit to the bondholder because there's still a bond over it. Whether the bond is up to date, maybe the bond is up to date, but the levies are not paid. The bond may be up to date, and the bondholder is saying, no, there's a bond of 500,000, and until you get my 500,000, then you must know that they will not consent to that sale, number one, and number two, they will object to the transfer of the property. So you as a sheriff will say, okay, yes, we understand, but you need to amend your conditions of sale, like you said, or you should have told the bondholder, you know what, you are to attend the sale on the day. You have to protect your client's interest, not just merely supplying me with the certificate of balance. I will take it. I will forward it to the instructing attorneys, and they will say they'll all they will do is note it, but they will say you have to come and obviously protect your interest.
Okay.
You will not be you will not be able to sell that property without a reserve if there's a bond outstanding. You cannot, because there's a claim.
Yes, yes, and if I may add to that, it's always important to because that's information that you will get upfront often. It is always important when you read your conditions on that particular sale, you pronounce on what is the amount of the bond outstanding,
Yeah.
so that even if the buyers are bidding on the understanding of no reserve, but they know that there is effectively a reserve in a form of that bond. In fact, in cases like that, the bondholder, the bank, will also indicate the minimum they are prepared to accept, even if it's not exactly the amount that is owing. And in that case, you know that the sale will not come back on account of the bank or of the outstanding bond. But all parties will then depart from the same knowledge, and then it is the decision of the buyers if they decide, because of the the amount of the rates and taxes owing, and also because of that amount of the bond, they are not participating. You cannot, as the sheriff, be blamed for no bid, no sale, if you do not receive a sale because of those conditions. Yeah. And then, Andy, there was a question earlier. Oops, there was a question earlier before that one. How do you bar a buyer if you suspect they are dishonest?
In the conditions of sale, I think there is a clause that says if some sheriffs use this clause, they say if the sheriff suspects that the bidder is unable to pay the deposit or the commission, he may accept it provisionally, or if he doesn't, then resell it. In order to bar that purchaser, if you do your own Rule 4611 applications, and you know that this buyer is a buyer that always cancels your sales, doesn't pay or doesn't honor, you can get an order to buy him from your sales for a year. So that's the only way by a court order. But in terms, if you're selling in terms of the CPA, you're the auctioneer, you can. It allows you. You just have, I saw it there the other day, but I can't see it now. But if you go through regarding bidders, you will find out there where it says you can ignore a bid, or you are allowed as auction not to accept a bid. It's there if you're selling in terms of the CPA. I see there's two questions. I want to answer the one for Ashley. She says, I disagree with you when you say the High Court rules and make provision to advertise. The 15 days was always the position. You are right. Can you guide us as to how many days you need to advertise in terms of the High Court? Well, I'll wait for you to respond so you can guide us, because we don't see it in the rule here or in any other rules. Then the next one, Yvonne, it says reserve price and the highest bid is, do I continue to sell to the highest bidder or I cancel due to the reserve not met? If you're going to accept, and you have accepted the deposit, and you have accepted your commission, and you've accepted that the bid, you can do the report and send it to court and let the court decide whether they will accept the 100,000 or not. So,
okay.
Yeah, and then it says, Naja said, no less than 5 days, not more than 15 days prior to auction. I think that was always there. That was always there.
Okay.
Yes.
All right. I think that the question on the different, on the bid less than the highest bid less than the reserve price has been answered. Yeah, has been answered. You do write your report for it, as long as there hasn't been any specifications on the court order about what the minimum lowest should be.
It says for fixed property. It says okay for fixed property, and for specific and no specific days for movable property. So so now you I see you now highlighted your questions. So this what we were dealing with before was movable property. So for for movable property, like we said from the outset, that there was never a guiding days that you advertise when it comes to movable property. But shareholders always adopted that principle that you've said now, no specific days, but not more than 5 days. That is what shareholders were adopting.
I'm sorry.
Then he says, can you please provide me the copy of the CPA? I think that question it was the email was sent with the attachments. That's the act. You'll find it in the act that we put up just now.
I think what was circulated is part of the act, and then there's also regulations attached to it. Yeah.
Yeah. Just before I hand over to you, to me, there's one more. I think Petro wanted me to talk about was the registrations. I see Sanjay says he follows the magistrate court requirements regarding advertising. I think most of the officers do. They follow the Mag Court requirements for the High Court, and they say to the attorney, you know what, this is the days that I require my advert to be placed. Coming back to the CPA, it is imperative that the shareholders follow that process now that you are going to sell online. You are going to sell online, unfortunately, through the channels. The banks will now want you to sell online regarding their properties of all the nonsense that happens at the shareholders immovable property sales and even movable of the syndicates. So you're going to be faced with challenges regarding the CPA. So it's imperative that you get hold of the act. The act is there. And like there's one question, how do you buy a bidder? It's there. If you say you are following the CPA, that's what you need to say to your buyers, because the buyers are always under the impression it's a sheriff's auction, I can do what I want to do. Because there's some sheriffs that do not take a deposit for registering of the buyers, because you are familiar with them, they are your regulars, you don't do it. But when you're going to be placed in a position where you didn't have to take action against a purchaser or a bidder that continuously rigging your auction or causing problem, you can't enforce those rules if you haven't got them to sign your rules of auction. And your rules of auction complies or compels them to follow the CPA. And that is where you will get grip or you get hold of your auction. You control your auction, not they controlling your auctions for you. So it's imperative that this is what you need to do going forward after this training, that the CPA be fully implemented in your offices. You have not been doing it all to its standards. More so ever now that you are compelled, that they might come to you and say, I want you to do an online auction. And you're going to get some of the CCMA people coming to you and say, no, you must sell online or you must do it on social media. You're going to get those type of things. But you need to say, no, I can do it online because the rules allow me to do it. Then the last one I need to touch on is 2.7, the conditions of sale of immovable property. You'll see that there's an attachment there that was sent to you regarding conditions of sale. I think that is for the regional court, conditions. They haven't changed the ones that we are going to use. Obviously, now once online auctions are taken, seriously by the banks, and they'll say, right, or the creditors of the attorneys of the banks that say, no, we want you to sell online, then obviously it must accommodate. So it's the important thing about selling online regarding your conditions of sale, it must state. If it doesn't state on your conditions of sale that you have to sell online, that means you can only sell on site. If it doesn't make provisions for online, you cannot sell online if the provision, if the conditions do not state it. I can see Petra has put it up. You can see that they've just given you a template that needs to be used if you are selling. You just scroll Petra page 2. As you can see. Yes, keep scrolling till the end. This is a copy of the conditions of sale that is used in the regional court. So, this was also attached to the email that was sent to you, but these are the conditions of sale. So when an attorney is going to obviously tell you sell online, you will then insert that it has to be compliant with the CPA, that you need to be a registered bidder and follow the rules of auction. Those are the things he's going to put on. And then obviously, if you are using a dedicated website or a host, like some sharers are using, are currently using their properties to be sold online, and it is working for some sharers very well because they've been doing it a long time, then that website address has to be on that. So whoever reads the conditions online or reads the conditions at your office, or they get hold of it, or the debtor gets hold of it, he will then log in to see how his property is being sold online and what bids they were receiving online and what bids they were receiving on site. Okay, that brings my 2.1 to 2.7 to an end. Is there any questions that you have?
Okay. Any questions going on that, on everything that Andy has presented on? Yes. Rates and taxes. Yes, this is that is the next item coming. SK. Okay.
Okay. Yeah.
Okay. Thank you very much, Andy. I think we have covered the much of that section with the questions. If there are any further questions, I'm sure they can continue to be shared, or even comments and experiences on the group, as we usually would do. But thank you so much for that elaborate presentation.
To me, before you can, I see Fred got his hand up. Fred?
Hand up. Oh, okay. Fred, can you come in, please? Oh, I see. No. Is Haneli Frida hand up? I see. Frida. Frida, your hand is up.
Yes,
come in.
Question was, I wanted to be clarified about this body corporate issues, because these days I'm having auctions of body corporate that are coming so much. So the stance is, if the preferred creditor is not met, I shouldn't sell. The body corporate is there, the sale it's on. So if nobody is bidding to the reserve of the bank, I shouldn't sell. Is that what the stance is? Or should I wait for the bank to ratify my sale, or what is it?
You can do two things. You'll allow the sale to go on, and then, like you said, the bank will ratify the sale. Or you say to the body corporate, there is a bond outstanding. And if the bond is 800,000 and you want 250,000, there's no way the bank is going to consent to your sale. So you can go ahead and say, I'll do your sale, and the bank will write back and say, we do not consent to your sale. But you need to put pressure on the bank's attorneys or whoever represents the banks that they need to set their reserve timelessly before they go, because they might find themselves on the other side when they go to court. The judge will say, but you had time to obviously say to us what your reserve price was.
But then
So,
also to make
yeah.
argument, but then like I liked what the other speaker said about I announce it to say there's a preference creditor who's owed 1.4 million, and it is not in my conditions of sale. Then I sell with the amount of the body corporate, which is 200,000 over 1.5 M, and awaits the ratification. But I don't have it in what we are going to sign. That is my beef. You know, what we are signing and what I'm telling the people, and they don't align and meet. So it also worries me.
You see,
Yeah, I think if I may come in there, and look, it's always safe and important to have. It is, yes, not in your conditions, but you normally would get a written position, a written statement by the bondholder indicating to you. So that is there in writing, and it is brought to your attention as the seller, as the sheriff. So you then have the responsibility to announce it. I also have had a similar situation where the representative of the body corporate was arguing that if the bank was not there to protect its interests, then there is nothing compelling me to sell subject to their
Colleagues, there's no sound.
I think Tumi maybe got cut off.
Okay. Sorry. Yes, yeah. I'm saying it's always important to have that information. Once you announce it, the buyers will decide whether they are going to buy subject to approval by the bondholder, or if that is what the bondholder is having as outstanding and cannot accept what is offered, then they don't buy. So it's a report of no bid, no sale. Usually that is how it is easily sorted out. But you deal with it almost the same way as your Section 66, where it is subject to that ratification. All right.
There's two questions.
What do you do when the bank sent you a COB stating clearly that the reserve should be 1 million? That is the bank. And the body corporate insists you sell, and if the bondholder wanted to protect their interest, they should be there. But the COB should be enough. What protects the sheriff? Yeah, I think this is what we have been arguing. Yeah. Because and this comes from my office. That's the recent experience that we have had, where the representative of the body corporate was even threatening to take us to court because there is nothing that says we must observe the position and the interest of and protect the interest of the bondholder.
Okay. To me, I see there's one question. Good morning, colleagues. Once we file the Rule 9D report at court, can the purchaser cancel his offer? What is the procedure? Once the report is in court, the purchaser cannot cancel his cannot cancel his offer made. If the scenario, if the court agrees to his offer and he doesn't perform, then obviously the attorney will have to comply with Rule 4611. They will then proceed with Rule 4611. Unfortunately, he cannot withdraw his offer that he's made. You've already filed your report, and he must wait for the outcome.
Okay, that's in order. Unless the cancellation, there will be other factors emerging that do not necessarily attribute the cancellation to non-compliance of the purchaser. But once it is there and it is a pure Rule 4611, it cannot be cancelled. Okay. Is there any question we are leaving out there on this section? Once we file a Rule 9 court purchase cancel offer, and what is the proceed? No. This is what you have been answered. You have been answering, Andy.
Yeah.
Normally, I think another side to this question is, if the the 9D report has been submitted and it is taking forever to come back, and the question is, in that process, during that period, does the purchaser have any latitude to say, I can't wait any longer and I would like to withdraw from this sale? What I have seen happening is not purely withdrawing from the sale as it is. If there is an outcome by the court, we will get a report that says the attorneys should establish whether the purchaser is still interested in buying.
Hello?
Is still interested in buying. Can you hear me? Hello?
Yes, we hear you.
Okay. Yes, there would be that kind of an inquiry. And once the purchaser confirms that they still want to proceed with the sale, then they cannot come out of it. But we have had an instance where a buyer had indicated that they would want to proceed, because the court would also want to inquire. Part of the judgment would be, of the order would be, to establish if the purchaser is still interested to proceed. Then they say yes. But for some reason, after doing their things, they will lease out the property, this and that and that. Then they come back and say no, they no longer want to proceed and raise delay as their excuse and reason. In that case, we were able to insist on Rule 46 because the initial response of the purchaser was their willingness to proceed, which changed later in the process. Okay.
Just before
yeah.
you can, there's two other questions. We'll deal with those and then you can carry on.
Good morning. Where are the other questions?
It's on the
right.
chat.
Oh, on the chat. Okay. The the question from Louise and the question from no. Where do I oh yes. Reader, it will depend if your judgment for levies is in the magistrate's court, then it is subject to confirmation by the bondholder. In the High Court, I understand the position is that once the bondholder has been notified of the sale and they do not attend the sale is not subject to confirmation. Okay, yes, this is what we have been saying if the buyer insists on buying, how long may we keep the online auction for? Can we take bids until 12 a.m.? Okay, and then instructing, Andy, I want you to deal with both questions, the how long part, and then the instructing attorney was busy with the application but has just passed on, and now the purchaser is receiving calls from the execution creditor to cancel the sale. The creditor, the attorney is the one who passed on and not the sale itself. So the attorney does not pass with the agreement or with the purchase. I don't know, and can you come in on that one, on these two?
Yeah, no, you're right. Unfortunately, another instructing attorney the bank will then move it to someone else. You just need to explain to the purchaser, it is what it is. You have to follow the court rules. Your application will obviously be transferred to another attorney now, but you have to follow the rule 4690. In terms of Nomadi's one, how long can we keep the auction for? Can we take bids after 12 a.m.? Remember, you got if you are conducting an auction, it's a sale in execution, but you're holding it online. And if you're selling concurrent, then if you are starting at 10, that your online auction will obviously start at 10 simultaneously. And whatever time you finish. You will, otherwise, if you allow your online auction to carry on at 12 and you get better bids there, and then the on-site bidders will say, on-site bidders will say, but we could have also pushed up the price a little bit more. We were prejudiced because you left the online platform on more longer than your on-site one. So that you need to guard yourself. If you're going to do it like that, then you must let the other on-site buyers say to them, my online auction opens at 10 and it's going to close at 12. But my on-site auction, because the goods are here, is obviously going to take an hour. But should you still want to pursue the bids online, you are able to. But that needs to be on your conditions. That needs to be accepted by the creditors' attorneys as well.
Oh, okay. I hope that is clear. It depends on the time frames and that you have set out. The parameters that you have set both for online as well as the on-site ones. I think this brings us then to the end of this session. Just also to note that even on the rule amendment emphasizes simultaneous, which means it is not a purely online, unless there's COVID, but it's not a pure online. So it must be a hybrid of both online and off and on site. Okay, I'm moving on. Can we to the next item, which is the 118 item, part of the conditions. I think Andy has dealt with a number of a lot of what is in the conditions of sales that we need to take care of. But the section that I am dealing with now has specifically to deal with that section of the conditions, which outlines the liability of the purchaser on amounts due to on costs, including amounts due to the municipality as well as the levies, but specifically those that are due to the municipality. There has been inconsistencies, colleagues, about this particular section. And also that even us as sheriffs, we have dealt with it differently, maybe overlooked it when you just go through the conditions, because some conditions will specifically say all amounts due to the municipality serving the property in terms of section, there it is, in terms of section 118, ne? And 1181 or 1182. The buyers have also gotten to know that that is the condition. In the conditions, you will find that their liability is limited to 118. Now, where the conditions the conditions are not specific to 118, but only mentions Municipal Systems Act, in terms of the Municipal System Act, and does not specify the 118 condition, then you find the buyers wanting to challenge this specific one, to challenge the attorneys in the event that there will be an expectation for them, for the buyers to pay more than what was announced, and more than and the historical debt beyond 2 years. So what has come out very clear on this section and practice is that the conditions will specify, even where the conditions are saying sale, you are liable for all amounts in terms of 118, which by implication meaning that you are only, that is, the buyer is liable only for rates and taxes for not more than 2 years or beyond or for the historical debt. The conditions further say, and all other amounts due to the municipality. Here, on all other duties that may be due to the municipality. And the question again around the fact that these figures that are announced are only estimates. Now, when we look at, I'm just going to deal with this session also using the court order that we have here, the judgment here that we have in this regard, this Langlaagte truck car and eThekwini. On this matter, the applicant was prepared to pay, to settle the outstanding rates and taxes as they were announced or they were offered initially. And at a later stage, when the municipality was prepared again, now this on this one, you find that the parties are the municipality and the buyer. The challenge here is the applicant insisting on paying nothing more than the estimation, and nothing more than what is owed to the municipality for 2 years. So, what was the question in this order was to establish whether the buyer is liable for the historical debt that was older than 2 years. If you go to if you go to point number 6 on that order, number 6 on the judgment, point number 6. I don't see pages, right? Yes, point number 6. This is what would be in the conditions: costs and charges, and clearly stating 118, 6.1.1, 6.11 there, indicating clearly that liability is in terms of 118. But I once again, I'm saying the catch here is that it says and duties that may be due to the municipality. Now, if you go to point 6.3, 6.3 of this, 6.3 says the purchaser notes that, and the purchaser here was the applicant. The purchaser notes that the amount indicated by the sheriff as owing in respect of that clause are estimates only. Neither the sheriff nor the execution creditor warrants the accuracy. Yes, this is what is also in the conditions. The purchaser shall not be able to avoid these costs, but the actual amount owing in respect of must be paid by the purchaser. However, the applicant's contention here was that it complied with the conditions of sale when they paid or they settled the amount that was mentioned, and the rates figures set out as an indebtedness to the respondent by the judgment debtor in that sum. This is the sum that was more than what was paid by the buyer. Is the responsibility of the debtor. So the argument here by the applicant was that they are not liable for any amount beyond 113, beyond the 2 years which is stipulated in terms of that section 118. However, the municipality continued to argue that even though it is the on the part of the buyer, the figures are estimates and they are noted as estimates. So if they are estimates, they can become anything beyond what was stipulated on the conditions of sale. And furthermore, the argument of the municipality here was that that stipulation, the wording that over and above 118, any other amount owing could then accommodate even that historical debt. That the historical debt, yes, is understood. It's in the history, but it could also be read to be accommodated by that statement as any other debt. Number 13 there of that judgment, when there is a historical debt and there is uncertainty regarding who will pay for it, the respondent is entitled, that is the municipality, to interdict any sale in order to secure its rights. It threatened to do so in this matter particularly, but the applicant opted to pay the amounts outstanding, albeit under protest. Now, this is exactly the same as a matter that was that we had to deal with, and in that matter, the two parties were the buyer and the and the judgment creditor, ne? The judgment creditors athini. The conditions of sale then did not mention 118 specifically. But the purchaser, because of practice, I mean, of practice and what they usually would see happening, insisted that the judgment creditor may not insist on them paying the historical debt because it is illegal. What is legal should be in terms of 118, because the new buyer cannot be held liable for the historical debt beyond 2 years. And, yes. So that I'm saying with the on the judgment, on this judgment, the court actually found that even though the conditions stipulated 118, the debtor, I mean the purchaser was found to be liable because of that caveat that says, and any other amounts that may be due. So the historical debt is now added into the conditions as part of that any other. That is as far as this judgment is concerned. But on this other matter, where the two parties were the purchaser and the judgment creditor, the municipality had gone on to issue figures, settlement figures, clearance figures, and the buyer paid those clearance figures and issued the clearance certificate. But the judgment creditors attorneys refused to accept and actually wanted us to apply for the 611 cancellation, because in their view there was non-compliance with the conditions, because their conditions were saying 118. It just got messy up to a point where we even had to appoint an alternative conveyancer, because the purchaser's view was that in terms of the conditions, if the appointed conveyancer by the judgment creditor does not perform satisfactorily and in time, you, the sheriff, have to appoint an alternative conveyancer. So, colleagues, I think the lesson on these two scenarios is that the sheriff should settle the conditions. The sheriff should read and understand the conditions, and then these conditions must also be, in the same way as we were referring to what is owed to the bondholder. The person signing must be aware of what the conditions are saying, because this Gazette notice now that is before us was effective in August, and that was after all these experiences that I'm mentioning prior, save for this judgment. And at that, when this Gazette notice was published, I was able to share with the buyers that this is what now the rules is. On the High Court, on the Match Court, Regional Court, and District Court, we can no longer be going insisting on 118 if 118 is not specified. The Form 21, as you might have seen it there, does not even mention 118 itself, and this is for the High Court. But we still find in some of the High Court conditions attorneys saying in terms of 118. So We just need to be alert of what the conditions are saying and bring this to the full attention of the buyers. We cannot return the conditions. You see, before the Gazette notice, you would, if you are not comfortable with the conditions that do not specify 118, go back to the attorneys. Some attorneys would amend to say 118, and others will say no, but Form 21 does not provide for 118. But now that this has now been gazetted as it is now, there is no basis on which a sheriff can insist on the inclusion of 118 across. I mean, for lower court conditions and as well as the municipalities. I mean, the high court conditions. I am told that this court, this judgment is being appealed. Yeah, we stand to see what the outcome of the appeal is saying, because here, if it is being appealed, it means that the judgment, the purchaser is challenging the decision that they are liable to pay rates and taxes beyond 2 years, and which is the historical debt. Thank you. Any question? I see Petro. To me, what process do you follow to replace the conveyancer? A very interesting one, this one. Firstly, the replacement must agree to taking over your power of attorney. So you have to do that. So you need to firstly inform in writing officially to the appointed conveyancer your reasons for not being satisfied. I mean, it is in the conditions of sale. You will cite that section of that provision of the conditions of sale, and they will agree or not agree. In this case, they did not agree, because they wanted to go Rule 4611 at all costs, and they did not agree until there were now issues of court case between themselves, which is the judgment creditor and the buyer. Then after a while, then they said no, they are in our correspondence, they are prepared. Once I appoint, they acknowledge my powers in terms of that section, and then I must inform them of who the new conveyancer is. Then approach a new conveyancer. In fact, the attorney representing the buyer wanted to bring conveyancers himself, but we chose to stay neutral and appoint our own conveyancer who is not linked to either of the two. That conveyancer, for him to agree, we had to give him indemnity, because he now demanded for us to give them, ourselves and the buyer, to indemnify him from any action that would be taken by the judgment creditor, because the argument, the basis of refusal for transfer and so forth by the first conveyancer was non-compliance, that the conditions do not specify 118, whilst the purchaser insists that there is no legal basis for the creditor to insist on them paying the historical debt, whilst the municipality has issued a clearance certificate. Once the municipality had a clearance certificate, the attorneys of the judgment creditor had no business to oppose the transfer. But their other base argument was that if it continues like that, they are going to pay less than what it is owed to the municipality, and that is prejudicial to the judgment debtor, who in this instance was not even their client. So yeah, that's how it went. But you first have to really get a concurrence of this of the other attorney, and then write to the initial attorneys that this is who you are appointing, and they must return all your documents to you. Your power of attorney is withdrawn, and you are now granting it to this new attorney. Look, if there's no animosity, they will provide. They can even transfer the documents directly to the other attorney. But in this instance, the documents all had to come back to me for me to hand them over to the new appointed conveyancer. Fortunately, it finalized. The matter finalized without any further court action. But it had ripple effects. I mean, it had snowballing effects in that there were delays, and now interest was higher, and the purchaser now refused to pay the interest, did not objected to the distribution report. Until I also had to come in and prevail on what interest, who was responsible for the delay, so that interest has come to that point. Okay, I think that is the background. I'm just trying to read. Rashad, in a rate sale for municipality, does the purchase price go towards paying a rate sale, go towards the warrant, or does it go towards the warrant? The purchase price go towards paying to the warrant? Yes, if the warrant would have then been moved by the municipality itself as a creditor, because then what is owed there is its rate, then it will go towards the rate, the warrant. It will go towards the warrant. I know that some of the purchasers have argued that no, actually the rates and taxes, and here is when the body corporate was involved, that some of what is the purchase price must be split between the warrant of the body corporate and the municipality. But that did not happen. I mean, what happened is the payment of the purchase price went directly towards the warrant. The condition, okay?
To me, on that one, there's a twofold in that one.
Yes.
If it was sold for rates, then obviously they'll pay the purchase price for the rates. But also bear in mind that the purchaser has to pay the rates and taxes and the levies to take transfer. So technically, there might be a surplus that is due to the defendant or the bondholder. So that doesn't mean that if you sold for rates, you settle the rates. Then what did the defendant pay? What did the purchaser pay to take transfer of the property? So the must also take notice of that. Now, not all the money will go to the municipality if the purchaser is actually going to pay the rates and taxes and the levies to take transfer of the property, because that is one of the conditions.
Yeah. Yes. What end means is that even if there is a warrant and the payment is going towards the warrant, you still have to, and that is why this other purchaser was arguing that no, I can't pay the warrant amount, and then I still have to pay the municipality. The municipality must get its rates and taxes from the purchase price. No, that must still be paid because there would be no transfer if the rates and taxes as even indicated or announced in the conditions would not be settled. The conditions of sale is being drawn up by attorneys. Yeah, I have found that it is not a uniform format. Correct. It's not a uniform format. I'm going to have. Yeah, it's not a uniform format, but use different formats. If the 118 is not included by the attorney, do we request attorneys to include it? They supposed to use uniform formats, conditions of sale. 118 not included, can it then, I then refuse. Yeah, this is where I indicated that prior to the Government Gazette of August, you would be able to return the Gazette note, I mean the conditions to say, but the condition there is, if it is not 118, the attorneys must amend them. And I said some of the attorneys would, most of them, in fact, would amend it. Even this one that I had an issue with about appointing a different one, amended the conditions where we would return them. Others would say no. Form 21 does not say 118. And that is Form 21, remember, is now in terms of the High Court. Does not say 118. So that is where you will have the wrangle. But now that there is a Gazette notice that has been published to say High Court, I mean District Court and Regional Court, all amounts, it says all amounts owing. So if there's no 118 there is no leg for you, Sheriff, to return. You accept them. You just need to bring this to the sharp attention of the buyer, that this is what it is. If they go and negotiate it themselves with the municipality and stuff, it's fine. But the conditions themselves will be saying all amounts due to the municipality. And that is what this court order, this judgment now is saying, that you would, it is reversing what was initially established. You remember how 118 came about, that that it was also prejudicial on the purchaser to be held responsible, liable for 10 years or 18 years debt that was accumulated by the judgment date. But now it is going the reverse way. If you look at it, that this Gazette is changing that. This court order if it is not successfully appealed, will also present a situation where you can't insist on 118. But as it were, Form 21 itself does not say 118. It says all amounts. Even where it says even where the conditions are saying 118, now this court order says, and any other amount owing, and any other amount owing is construed to include that historical debt. It will be interesting how the appeal will go on this one. Okay.
To me, further to that one, that is why it's imperative, sheriffs, that when you are correct, they will insert the amounts on your conditions of sale to settle it. But on the day, they will give you a revised figure. And in terms of the CPA, its onus is on the sheriff to disclose those amounts. Let's say when the time of settling of the conditions, the rates and taxes was 117,000. But on the day of the sale, which maybe was 2 months or 3 months, they're going to say the rates and taxes outstanding is 158,000. So that's what you need to announce, because that is in terms of the CPA. The CPA requires you to, like, any defects, if you are selling, you are to bring it to the attention of the bidders. Same applies for the immovable. That all figures are to be disclosed at the time of auction. It's imperative that some of them say, okay, these are the figures, insert it now, and you sign and they share. That is what you disclosed on the day of the sale.
Okay. Okay, then there's this one question. What does the purchaser then pay? The rule states must pay all amounts. If the rule says they must pay all amounts, will the sale amount be taken from the amounts due for rates? No, the sale amount, if the sale is not for rates and taxes, but the rates and but the outstanding rates and taxes are there stipulated, given to you, like in he's saying, you have to bring them up to attention. And in fact, sometimes you even pick them up from the floor, the correct, the accurate ones, or the almost accurate one, because everything at that point is assumed to be, is presumed to be estimates, but they should be paid. They cannot be taken from the purchase price. Then I think in as much as we are obliged to put the purchaser on terms and give breach notice, the same should apply to the conveyancer. Yes. Give them notice that you are about to exercise your rights. You are to exercise your right to change conveyancer due to their non-cooperation. If they do not remedy the breach within 5 days, then you will appoint a new conveyancer. I can't agree more, because if you do not do this, you can go on for 3 months, going from the purchaser to the conveyancer, to the purchaser, to the conveyancer, until there is that problem of interest, and then the purchaser also objecting to paying extended amounts of interest because they do not accept the responsibility for the delay. That is, if the conveyancer was the one not cooperating and delaying the process. Okay, any other question? I see, is there any question? Correct, Tami? Dumi can speak on this. Yes, definitely, that is what I've just said. There is a hand up, Haneli. Namedi, there is a hand up. Okay, Hannes, okay, let me take Namedi's and then I'll allow you to say. In a situation where there is a warrant against levies or rates, will the amounts raised in the sale in execution be refunded to the purchaser once they have paid the clearance amount? Well, I think depending on what on what was on the amount that was raised, I have seen. Yeah, this one is not on the bond, so you cannot pay the excess to the debt. You cannot. What amount in Namedi is Namedi talking about? Namedi is saying the warrant is for levies and rates and taxes. If it's for levies, rates and taxes, the question is, for levies, it would be coming from the body corporate. Rates and taxes would be the municipality. So it means you would be having two parties. Yeah, maybe we need clarity on that question. A scenario. Is a situation let's see. Now these things are moving too fast. Okay, that was Namedi. It's a situation where the body corporate gave figures and after the date of sale, they suddenly remember additional fees not cleared on the date of sale. Is the purchaser liable for the additional fees as well? They added almost 300,000 to the clearance amount. Yeah, this question, colleague, I think is a similar situation as what is in this Langlaagte track, judgment, where the figures now for settlement of rates for clearance were more than what was pronounced at the time of the sale. The court here says what was announced was only estimates, and further that section of the condition sets 118 and any other amounts owing to the municipality. So as I say, let's follow this process, this judgment, and see where it ends. Maybe it will give us directive there. Hannes, can you come in before I go to Haneli? Hannes?
Yes, Tumi, I'm here. How are you? Can you guys hear me?
Yeah. Thank you. Yeah, good. Thank you. You can proceed.
Okay, great stuff. Yeah, this section 118 is giving a lot of conflict and a lot of unhappiness. Because if the attorney said in the conditions of section 118, and then the municipality, they don't give the correct figures, they just give all amounts outstanding. Then I asked the attorney, listen, you put in the conditions section 118, so please provide me. The attorney says the municipality doesn't comply. So what I do in the auction, I tell the guys, listen guys, I explain them section 118 and the constitutional judgment on it, but I say the following: it is your responsibility to go enforce your rights. It's not a sheriff, it's your responsibility to go and enforce your rights on 2 years, because the municipality just charge 100,000 rand interest and stuff like that, and they just don't care. So we had a lot of controversy on this, and the people is unhappy about this, because if it's too high, the people say, listen, we're not going to attend the auctions anymore. So yeah, we have a bit of a problem with that section 118. So is it correct if I tell them, listen, it's your responsibility, you go and to your attorney and you see that you get your rights forced down on that? Or mustn't we just read that and say section 118? Do we need to explain section 118, or what is your take on that?
Okay. I think I'm sure colleagues can also come in here, but I think the one thing that I have noted here for our note as sheriffs is you really need to be clear of your role in this whole thing. You need to be clear of what your role is, lest you find yourself vacillating between parties. And your role is clearly defined by the conditions. And the CPA, the conditions, you don't want to. You don't want to. Okay. Somebody is can I get somebody saying? Hello? Hannes, I agree. I also advise buyers, even on Rule 46.9, I advise the buyers to make an affidavit to support their bid. Yes. Look, the question about the attorneys giving figures, you have got no control over them. You can't be the one verifying with the municipality what is the rates and taxes all the time. You depend on the attorneys for the figures that they give you, and like Andy has indicated earlier, you will get these figures in advance. A day or two, or even on the day of the auction, you will confirm with the attorneys if the figures are the same. That is before the auction. You will get confirmation if the figures are still the same or they have changed. In some instances, you even get your buyers who are experienced, who will do their own homework and tell you right at the auction that the figures are incorrect. Here is the new figures. I always ask, is there any new information on the floor? And then you will either get it or you will not get it. But the question around estimates, yes, you are right to to talk up to invoke the correctness of information on the CPA, that you should give people information. But unfortunately, in this instance, as the sheriff, you will not be in a position you will not be in a position to guarantee the correctness of the figures. Hence, in the caveat that they are only estimates. And when that happens, then it becomes a matter between the purchaser and the municipality, because unless that has been settled, clearance certificate cannot be issued and the transfer will not proceed. Okay. Any other question? I think this colleagues, I agree with most sentiments here, that this is a very hot, and it can become very challenging because our regular buyers, they act, I mean, they are little attorneys themselves now. They know, and they will tell you why an attorney cannot say, they are liable for something when the law says they are, when the CPA says this. But the starting point is the conditions. Make sure that the provisions of the conditions, you have understood them, and you can defend your signing, your agreement as the sheriff, and your duty to explain and to inform of the conditions. And if any other thing emerges between the two, then you know what your rights are, but you know how far you can go. Because when now it becomes a Rule 4611 thing, because you see, like in this instance where I say the attorneys themselves, the conveyancers, were now threatening to cancel the sale, wanting to cancel the sale. It means the sheriff had to come in, because Rule 4611 drafted by them, it is my affidavit, it is my submission as the sheriff. So I have to agree with it. So when I don't agree with the reasons for cancellation, then it creates a problem. I cannot cancel. I will go on further to even finalize, appoint an alternative conveyancer like I did, but then I get again challenged when it comes to the distribution account, because now there are all these issues that are raised because there was no agreement and there was more time spent on the argument, causing the interest to increase. But please, please, please do look at your conditions. I have seen instances where attorneys put ridiculous conditions in bold. They know they are wrong, but they put a condition in bold saying subject to approval by the seller. Yeah, subject to approval by the judgment creditor. There is no bond, there is nothing, and then we just glance through and we sign the conditions. There is that section which is in bold, underlined. We did not look at it, and that is the one that catches you, that you can't proceed with the sale. And you are then caught between the judgment creditor and the purchaser. But yeah, I think this is something that should still be pursued. Safe to say that the rules now we have this gazette notice. It is very clear. We cannot challenge it. We can't contest it. As far as the High Court is concerned, we can't wait to see the outcome of this judgment, because then it will say if the appeal is won, is successful, then it means that we can insist on High Court 118. But as it is now, we can't. Right. This concludes today's training and this section. I don't know if there's any other thing, any other question, comment, but on this one, maybe the conclusion is that it's to be continued. We will look at other appropriate fora where this discussion can be continued with different experiences. Colleagues, if there are no other questions, I would like to thank you all for your patience, participation, vibrancy, and thank you very much, Andy, for the presentation. Thanks a lot to Pedro, Max, and Martin, who are in the team, the training team. This was another, I want to believe, a successful and exciting online training. And I think online will be the way if we want to cover a lot of ground. This does not mean that there will be no physical trainings. There will be, but a lot of changes and amendments that we need to catch up with, I'm sure will be greatly covered online. Andy, please supply any other topics. Yes, please. If there is any other thing, any other burning topic that colleagues would like to have discussed, considered, workshopped, let them come through to the committee to consider. Constitutional Court judgment overrule any other courts or conditions. Yes, we agree. We agree with you 101%, Hannes. We want to, that's why we really want to, I think maybe the legal team of SASS can look at those judgments and draw our attention to them as they relate to various issues that are challenging us, and particularly this one of the rates and taxes. Thank you very much, colleagues. Is there anything I am leaving? Anything from the team going? Can I please have the name of the pending case? The case is case number. It is there. It has been circulated. It has been circulated with the documentation. You will get it as part of the package for today's training if you have not gotten it. But it's Langlaagte Truck and Car Hire and eThekwini Municipality. Judgment of 31st October 2024. Case 9219 of 2023. Okay, colleagues, on that note, thank you very much and enjoy your day further.
Thank you. Bye.